morning and welcome to our first virtual mock trial. Today we're going to be looking at a possible future, the new normal, mock trials in delegates' cases. This training is aimed at familiarising people with what a trial will look like in the virtual world, so it's a virtual mock trial. We've aimed to make it as realistic as we possibly can. The scenario is a highway scenario, but it contains some universal application risk management points. We hope that you will enjoy it. We hope that it will give you a view of how these are going to work in the future. The trial bundle can be found in your handout box on the screen. Council will also be referring to documents which will come up on screen during the course of the trial. You have a chat function which will enable you to ask us some questions. We're hoping to be done with time for questions at the end of it. We also have to say that we are recording this, so any questions that we come in, we will ask anonymously. The final point is that there's no fire alarm test scheduled today, so if you hear a fire alarm, somebody has a problem somewhere. So without further ado, it's time for us to move off to the Gotham County Court and to the case of Dominique Cummings versus Gotham City Council. But before we start, if I can just introduce everybody. We have two barristers with us, Andrew McNamara and Nick Robinson from Ropewalk Chambers. They've kindly agreed to help us. Nick's for the claimant. Nick, can you give them a wave?
Good morning.
Morning. Andrew for the defendant.
Morning.
Our claimant, Dominique Goings, is being played by Denise Holt. Denise, can you give us a wave? And then finally, Andrew Clark as the defendant's witness, Randolph Rhodes.
Morning, everyone.
Excellent. Right, so without further ado, we now have to imagine that we are in the future. This trial is taking place in November 2020, so it's a few months down the line. What the world will look like in November, I don't know, but the upshot is that we are now fast forwarding to a trial on the 10th of November. So into character. Good morning, everybody. I am District Judge Birmingham. This is the case, case number G34 NC 1701, Dominique Goings versus Gotham City Council. I understand that I am assisted by Mr. Robinson for the claimant.
Indeed, sir.
And Mr. McNamara for the defendant.
Good morning, sir.
I understand that the parties or witnesses, representatives of the parties are present. Ms. Goings?
Yes, sir.
And a representative of Gotham City Council, Mr. Rhodes.
Morning, sir.
Can I now confirm with Council the following, please? First, that the parties present consent to the matter being conducted as a remote hearing.
Yes, sir.
They do, sir.
That the parties have copies of the bundle or access to the bundle, doesn't matter if it's paper or electronic, and that they can refer to the bundle during the hearing.
Yes, sir.
Yes, sir.
That arrangements are in place to allow the parties to provide you with instructions during the course of the hearing if they need to.
Yes, sir.
Yes, sir.
The evidence will be given, excuse me, the evidence will be given on affirmation and the hearing will be recorded. Witnesses, I must remind you that when giving evidence, your evidence must be your evidence and yours alone. There is no rule against having people in the room with you during the course of your evidence, but they must not prompt, help, assist, remind you of your evidence. Your evidence must be yours and yours alone. This is a strict rule and you must comply with it. Witnesses, can you both please confirm that you understand what I have just said? Ms. Goings?
Yes, sir.
Mr. Rhodes?
Yes, sir.
The final point on practicalities is that the court systems can sometimes be a little bit temperamental, so it is important that people mute themselves whilst they are not talking. According to the papers I have, I understand that general damages have been agreed between council at £2,000. The items of special damages remain in dispute. I think that's all I need to say now. Mr. Robinson, can you please open the case for the claimant?
Yes, sir. Can I just check as well that you have skeletons from both sides?
I do, Mr. Robinson.
Grateful, sir. Yes, this claim involves an accident which occurred on the 14th of April 2020 The defendant is the local highway authority. There's no issue that the road in question, which was Carnaby Street in Gotham, was a highway maintainable at the public expense, and therefore the claim falls to be considered under the Highways Act. You will hear from two witnesses, as you've already identified, the claimant herself and Mr. Rhodes from the defendant. There is one further witness who is by paper statement only. As you've already identified, general damages have been agreed. It was a 6-week injury to the left ankle. In terms of the relevant considerations under the Highway Act, the defence puts the claimant to proof as to the occurrence and nature of the defect, occurrence of the accident and nature of the defect. And probably the most unusual aspect of this case relates to the Section 58 defence, because this was during the COVID-19 pandemic lockdown, and accordingly there's a question as to the reasonableness of the inspection regime in the particular circumstances of lockdown, where the defendant in essence suspended their inspections. I think really that covers it in broad terms, unless there's anything else you particularly wish me to address, sir.
No, Mr. Robinson, you should call your client.
In which case, I will call the claimant who wishes to affirm. Miss Goings, there should be some wording that comes up in order for you to take an affirmation. If when that comes up, I could ask you to read the words aloud for me, please.
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Thank you. And if I could now ask you to have a look at the trial bundle, which should be in front of you, and in particular at page 19, please. Do you have that in front of you, Miss Goings?
Not at the moment. Yes, I do now, yes.
Fine. That's the start of your statement. If you move through that to the final page, which is on page 21, there should be a signature.
Yes.
Do you recognise that statement?
Yes, that's my witness statement.
Thank you. And in terms of the signature, can you confirm that that's your signature?
That's my signature, yes.
And can you confirm that you've had the opportunity to read through that statement and it's true and accurate to the best of your knowledge and belief?
Yes, that's correct.
Thank you, sir. May that stand as the claimant's evidence in chief.
That's fine. Mr. McNamara? Mr.
Good morning,
McNamara, you are muted.
Good morning, Ms. Goings. I'd like to ask you some questions, please, on behalf of the local authority. Can I take you, first of all, please, to page 10 of the trial bundle, which is the particulars of claim?
Yes. Yes, I can see that.
Jolly good. And then on again, without going to the page after page 11, that's got your signature on as well. So you also signed that to declare that that was true as well, didn't you?
I did, yes.
Can you see your signature on page 11?
Yes, that's my signature.
Thank you. So if we go back to the previous page, please, on page 10, and we have a look at paragraph 3.
Yes.
So do you see there that what's been suggested on your behalf is that the pothole was of a particular size, and the suggestion is it had been there for some time?
Yes.
Now, it's right to say, isn't it, that there's no photograph of this pothole in the documents that you've disclosed, is there?
No.
And in fact, you didn't take a photograph of the hole that you allege was there.
I was unable to.
But the reality is you didn't go back after the accident and try and take a photograph, did you?
I couldn't walk, so no.
Right, so the answer is no, isn't it? And then what you also didn't do is you didn't at any stage measure this hole that you suggest was 4 inches deep, did you?
No, but when I dropped my phone is about 4 inches tall, and the phone landed where I fell. So that's how I know.
Ms. Gaines, are you seriously suggesting that you put your foot in a hole and presumably fell forwards, but your telephone fell into the hole you tripped it?
Yes.
I suggest to you that that is inherently unlikely and that you're simply manufacturing that to assist you.
No, definitely not.
So you'd have us believe your telephone dropped neatly into this hole, and that's what gave you an impression of how big it was.
When I scrambled around to find my phone, I could feel the defect, and then I put my phone against the defect, and it was sort of just around the same height as my phone.
Right. Okay. So let's just backtrack a minute. Why doesn't it say any of this in your witness statement? Which, if we have a look at it, it's on page 19.
I was just answering what was asked of me.
Yes, I appreciate that, but you'll realise that the particulars of claim suggest this hole was 4 inches deep. There's
Yes.
no indication either in the particulars of claim or in the statement that you have prepared as to how you came by that assessment.
No.
And now today, for the first time, you tell us that coincidentally your telephone, first of all, you said your telephone dropped into the hole, and now you're saying you shuffled around and put your telephone in the hole to gauge its depth.
Yes.
So which one is it? Did the phone fall into the hole, or did you shuffle around and use the phone as a depth gauge?
I think it was a bit of both. I think it fell near the hole, and then when I went to grab it, it was by the hole, and then I turned it round, and it was the same height as the hole.
Right, so your first answer was that this telephone fell into the hole, and now you're saying it fell close to the hole, and you simply used it as an indicator.
Yes.
And neither of those pieces of information appear in the witness statement, do they?
No.
So I suggest to you that you're just manufacturing this in an effort to try and get to the point where the court might have an idea as to why you say this thing was 4 inches deep.
No.
So you say the street lights were either not working or somehow or other they were off.
Yes.
That's just a guess, isn't it? At the time of this accident, it wouldn't have been necessarily pitch black, would it? Even though it was in late March, sorry, forgive me, mid-April.
Well, it was close to 11 o'clock in the evening, and it was dark, and the pub was closed, so there's no light coming from. Normally, when the pub's open, there's light coming from the pub, but there wasn't any because it was closed.
Would you do me a favour, please, and have a look at the very last page of the bundle, page 54.
Okay.
So do you see that? That's a piece from the Gotham Mercury from the 17th of April of 2020 that suggests that the pub in fact was open unlawfully during lockdown and was closed down as a consequence of a police raid.
I think that's a typo. I don't think that's correct. I think that refers to a different pub. I think that refers to the Thirsty Duck down the road.
If you look carefully, it says the Thirsty Ferret on Carnaby Street.
Yeah, but there's another pub called the Thirsty Duck further down Carnaby Street, and I think it's relating to that one.
Well, I'm suggesting to you the more likely explanation is that it was the Ferret, which is the pub, coincidentally, that you worked at.
No. I wasn't working on the evening.
Are you sure about that?
I never work on Titanic Day because I always take the day off to watch Titanic.
But nonetheless, you'd watch that film presumably during the afternoon.
No, I put it on about 6:30 till about 9:30.
So you didn't watch it in real time then, as you're so careful to point out in your statement?
I can't remember now, it was a long time ago.
So if we go back to your statement on page 19,
yes.
We can see there at paragraph 5, you go to great lengths to explain to us why it is you've got something of an interest in the film and the actual time at which the vessel hit the iceberg and then went down. So are you saying that you didn't watch this in real time?
Sorry, no, it was the afternoon.
So who was that who was helping you with that answer?
There was just no one.
Ms. Goings, I must remind you of my warning at the start. It is your evidence and your evidence alone that we need to be receiving here.
Oh, sorry, mate.
It is sir, not mate.
Sorry, sir.
Ms. Goings, who's off to your right, out of view of the camera?
No one now, they've gone.
Who was there a moment or two ago when you were prompted about your answer about the afternoon?
It was my brother.
Right. So your brother helped you with your evidence a moment or two ago, is that right?
No, it was unrelated. He was just he just shouted to me. He forgot that I was on the trial.
Ms. Goings, I would respectfully suggest to you that you're just making this up as you go along. It's quite obvious that you changed your answer as a consequence of some prompt from somebody off screen.
No, that was just a coincidence.
Well, I suggest to you it was more than a coincidence, that you're being assisted through your evidence by somebody else who might either have discussed it with you or has some idea about what actually happened.
No. No, I remember now, once you prompted me from the statement, I remembered that it was a little bit earlier that I watched the film.
So how far away is your house from the ferret then, either in terms of distance or time?
It's probably about 3 miles, so it'd take me about 55 minutes to get there.
Okay, so total round trip of nearly 2 hours.
No, well, ordinarily, but I had to get a taxi back because I couldn't walk.
I understand, but the point is this, isn't it? During the period of lockdown when this accident happened, the suggestion was that one should be out of the house for no more than 60 minutes, even if you're exercising.
Yes.
And what you had clearly anticipated is a journey taking a minimum of 1 hour and 3/4.
Yes.
So I would suggest to you that at the time this happened, what you were actually doing is you were in breach of the regulations which limited activity in order to stop the spread of the pandemic.
I didn't realise that there was a limitation. I just went out for my evening walk, as I did every evening around the same time.
But the fact is the pub that you were walking to was a longer journey than 30 minutes in both directions from your house, wasn't it?
Yes.
So when you got to Carnaby Street, if we have a look at page 20, we look at paragraph 7 of your witness statement.
Yes.
It would have been virtually deserted, wouldn't it?
Yes, there wasn't that many people around.
Nothing like the average evening at 5 to 11.
No.
And so the fact is that you were able to walk along there completely unimpeded. That is, there was nothing in your way.
No, yeah, that's right. Yeah.
You would have had a clear view of the road. You would have had a clear view of the footpath.
No, because the pub was closed because of the lockdown, and there was no street lights on. They were either broken or not working. There may have been a couple on. So no, I couldn't really see that much.
But you had a torch on your mobile phone, didn't you?
It wasn't so dark that I needed a torch, but it was dark enough that I couldn't see the surface of the road when I was walking.
All right. So you were effectively taking it for granted that the surface beneath you is safe. Is that what you're saying?
Yes.
You didn't check where you were going, even generally.
I was generally checking where I was going, but I wasn't looking at every single defect because I was concentrating on my journey and safely not to get knocked over in case there was any.
So, sorry, forgive me for interrupting. So you were walking along the footpath, weren't you? The pavement.
Yes.
Because that's why you make reference to the pavement in paragraph 7, isn't it?
Yes.
So would you mind having a look at page 31 for me, please? That should be the first page of Dr. McCoy's medical report. Do you remember going to see him?
It was a Skype It was a sort of a Skype interview, but yes, I remember it.
All right. So you had an appointment with him, and it was done in a similar way to this trial, so by video link.
Yeah, that's right. Yes.
Right. And do you see about halfway down on page 31, it says about history. There's a little subheading that says history.
Yes.
And it says that you told him that you were taking your daily exercise on Carnaby Street, and as you walked along the street, you described turning your ankle in a carriageway pothole.
Yes.
Now you understand the difference between the footway and the carriageway, don't you?
Yes.
So you've just told the judge that you fell on the pavement, or you were walking along the pavement, and that's where the hole was. And you told Dr. McCoy the hole was in the carriageway.
I was walking along the pavement, but there's a lot of side roads, so I was walking on and off the pavement. So I was on the carriageway, then on the pavement, and then on the carriageway again.
Ms. Goings, if you'd meant to explain to us that you were going on and then off of the carriageway, you'd have said so in your statement, wouldn't you?
Yeah, I'm not used to the court process. I don't know what to put in and what not to. I just followed my guidance.
Well, you were assisted in these proceedings by a solicitor, weren't you?
Yes.
And there's a photograph of the accident location, isn't there, on page 45? So if you have a look at page 45 of the bundle for me, please.
Okie doke. Yes.
Now we can see that that looks like quite a wide pedestrianised, there's a very wide pavement, isn't it, on the left-hand side of the photograph?
Yes.
And we can see also that there's although it's semi-pedestrianised as we look at the photograph, we can see there's a clear delineation between the footway and the carriageway, can't we?
Yes, I guess so.
And I would suggest to you that on the face of that photograph, there are very few side roads, at least on the left-hand side of the carriageway, and there's only one side road where we can see the zebra crossing on the right-hand side of the photograph.
Yeah, you can't really tell from that photograph.
Well, that's unfortunate, isn't it? Because it's the only one we've got. Did it not cross your mind in the light of your evidence to take more photographs to help us understand where you were?
As I say, I don't really understand the court process. I don't know what to do. I was just doing what I was told.
So when you fell over, you said you damaged these rather expensive training shoes of yours.
Yes.
It's back on page 20.
Yes.
So you explain that you fell over and you damaged your trainers and you smashed your telephone.
Yes.
So it's fair to say that your telephone would have been unusable, wouldn't it, as a consequence of dropping it and smashing it on the floor?
The camera immediately broke because I was going to take a photo of the defect, but I was still able to make a call.
So this is despite the fact that you've sought £500 for a replacement telephone, is it?
Well, I couldn't use the internet. I couldn't use the phone. I couldn't use anything on the phone other than I could dial the numbers.
I'm not following that. So was this a smartphone?
It was one of them phones. Yeah, it was a smartphone where you could ask them to ring a number. So I had to ask Siri to ring a number, but that was all it could do, nothing else.
Right,
but
so
luckily, I remembered the name of a taxi firm, a number of a taxi firm. So I asked Siri to call it, and it did, luckily.
So I suggest to you that, in fact, what happened is that you went inside the pub and used the telephone there, didn't you? Because your phone was broken beyond use.
No, the pub was closed.
And the reason that we know the phone was broken beyond use is because you've sought a complete replacement cost of it, haven't you? Namely £500.
It was broken beyond use because all I could do with it was voice activation. I couldn't do anything else. So there's no. So I needed a new phone.
Did you investigate having it repaired rather than having it replaced?
It was too far gone.
Whereabouts did you go to work this out? Did you go and have a quote from anybody?
I think I may have done. I can't remember. I've never been asked that question before.
Okay, but you went and you've got this letter from Mr. Groove about your trainers, but you've not got a letter or an invoice about the replacement or the repair of your phone.
No, it was all done online, so I haven't got a printer to print anything out, and I don't know whether I've still got it now. I may have deleted it.
You may have deleted it.
Yeah, I may have deleted it.
Presumably your solicitor would have asked you for the detail of this cost.
Possibly.
Did it not strike you that it might be useful in the event that you were going to claim £500 from this defendant to replace it?
I immediately replaced it. I didn't immediately think about making a claim.
So where's the cost of the replacement then? Where's the document that explains to us how much it cost to replace this phone?
Do you want me to have a look now? I can probably find it now.
No, that's fine. You haven't disclosed it in advance, have you?
No.
So who's Linda?
That's my next door neighbour.
Does she have a surname?
Dawson.
So is there any way that we could have contacted Linda in order to find out how and to what extent she helped you?
Do you know what? She helped me so much after the accident when I needed her that I didn't want to put her out anymore.
But she only lives next door. Even by maintaining social distancing, you could have easily asked her to prepare a statement and send it to the solicitor, couldn't you?
I just didn't want to put her out. I know what help she gave me, and I just thought I'm a believable person. I just thought I didn't think anyone would question Linda.
Now, Ms. Goings, can I suggest to you that on the night in question, in fact, your intention was to go to the Ferret to work?
Yeah.
And that's because the Ferret pub had been kept open, hadn't it, contrary to the lockdown regulations?
No.
And you'd gone there with the intention of meeting friends and overcoming your sadness about watching Titanic?
No.
And potentially drowning your sorrows?
No.
Are you sure? So the film finished earlier in the afternoon than you originally told us?
Yep.
Are you sure you didn't go to the Ferret and stay there and drink until 5 to 11 when you then came out of the pub and fell over because you were drunk?
No. No, that didn't happen.
Is that why perhaps you weren't so keen on going to the doctor that evening or going to accident and emergency?
No, I am petrified of going to accident and emergency, especially during lockdown. I did not want to catch COVID. I had my ankle was swollen, but I did not want to go to A&E.
So you managed with a damaged telephone to use the voice activation feature to call, luckily, a taxi service that you'd remembered the number for.
Yes.
You see, I suggest to you that this is just one coincidence after another. You fell over outside somewhere that you work, and then you ask us to believe that with a damaged telephone you were able to contact a taxi service.
It might sound like a coincidence, but it doesn't mean it's not true.
And moreover, you were out or you would have been out in total for something like an hour and 3/4 as a minimum if you'd walked to the Ferret and back.
Yeah, but actually I was back within the hour because I got a taxi.
You've got no evidence in relation to the actual depth of this hole. So, for example, no photograph or any diagram or description or indication as to precisely where it was, have you?
No, but I know the size of it because that's where my phone was.
I suggest to you, Ms. Goings, that this claim is manufactured and that in fact nothing of the sort happened, and you're just looking to the local authority to try and compensate you, aren't you?
No, that was my evening walk. I used to walk past the Ferret of an evening, and that was my walk. And just that night I fell over.
Very well, I don't have any more questions. Thank you, Ms. Goings.
Thank you, sir.
I have no questions. Mr. Robinson?
Just one question in re-examination. If we could just have a look at the photograph that you've already been referred to, just for the assistance of the judge, because he may not, I don't know how familiar he is with the area. It's page 45 of the bundle.
Yes.
What we can see in that photograph, we can see two bikes on a bike rack there. Could you identify where the public house is? Is it the building on the left with the hanging baskets?
Now, if you look to the right of the photograph, and there's some trees with sort of a low stone wall. That's the border of the car park of the pub.
Right. Okay. Thank you. That was the only question I had, sir.
Mr. Robinson, these photographs are, well, this photograph is very difficult to draw anything from. You might wish to remind your instructing solicitors that better photographs and a good understanding of where the claimant was assists the court tremendously.
I will do, sir, yes.
Is that your case then, Mr. Robinson?
That is the claimant's case, sir, yes.
Mr. McNamara?
Yes, thank you. Sir, I call Randolph Rhodes. His statement is on pages 26 to 30. And I wonder if I might have the affirmation up, please, for the witness's consideration. So first of all, please, Mr. Rhodes, would you have a look at the affirmation and read from it, please?
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. And if we could go back to your statement, please, which begins on page 26. That's a statement that bears your name, Mr. Rhodes, and it runs to page 30, where there should be a signature. If you could have a look at page 30 for me, please. Is that your signature?
It is, yes.
And do you recognise the statement, Mr. Rhodes?
Yes.
It's dated the 7th of September of 2020. Before you signed it, had you read through it?
Yes.
And had you satisfied yourself it was true?
Yes.
And have you had a chance to look through that statement again today in order to refresh your memory about its contents?
I have, yes.
Thank you. I wonder, sir, with your permission, I might ask 5 supplementary questions which relate only to the documents which follow, to establish whether this person is the author of them.
Yes, but be brief, Mr. McNamara.
Yes, of course.
It's supposed to be in the witness statement, a point you made to the claimant repeatedly.
Well, indeed. So, Mr. Rhodes, accompanying your statement is a succession of exhibits. Forgive me, they're in the disclosure documentation. Forgive me. Page 49 is the first one. There's a document there referred to as an inspection record. So page 49, thank you. Obviously, you're not the author of that, but are you able to assist us with, you made reference to Mr. Breeg in your statement as being one of the highways officers. Who would have been the author of that document?
That's Mr. Breeg's inspection record for Carnaby Street.
Thank you. And then over the page, on page 50, there's an internal memorandum. It's simply signed Chief. But were you a recipient of that document, Mr. Rhodes?
I was, yes.
Thank you. And then the next one is a document headed risk assessment, which has no name attached to it, but you refer to a risk assessment in your witness statement. Is that the document you referred to?
It is, yes.
Thank you. And then on page 52, the last document I want to ask you about, forgive me, the penultimate document, is an interim inspection policy which was formulated. Again, who was responsible for the creation of that document?
That was me.
Thank you. And then the last one, the spot and patch scheme, bears your name. Customarily, I imagine that document would have been signed. Is that something that you created?
It is, yes.
Thank you very much. I have no more questions for the time being. Thank you, sir.
Thank you, Mr. McNamara. Mr. Robinson?
Good morning, Mr. Rhodes. If we can just start with a couple of the documents. You're obviously a director of highways. Is it your evidence that the defendant has disclosed all relevant documents?
It is, yes.
Okay, so if we have a look, and appreciating you weren't the author of this document, but the document at 49, first of all, that you were just taken to, the inspection record. We can see, for example, just taking the first column or the first line across, 9th of January 2020, walked inspection, Ben Brieg, 7 defects, and then works order. Would there be any defendant document which identifies where those defects were, what they were, things like that?
There would be further detail within the works order itself.
Okay, have any of those been disclosed?
I'm not aware of that.
Okay, and just moving on then to your role, you don't have any hands-on experience in, experience is probably the wrong word, but your role doesn't involve any hands-on work inspecting highways. You have a director's role overseeing policy, is that right?
That's correct, though I am a qualified civil engineer.
Okay, and have you ever been involved in inspecting highways?
Not on the ground, no.
Okay. The layout in question, this area is the city centre, isn't it?
It is, yes.
Okay, and I think you describe it as, in essence, clothes shops, is that right?
That's correct, yes.
Okay, well, let's have a look at the photograph at page 45, first of all, please. You agree, I assume, with the location of the public house in question being on the right-hand side of that photograph?
I do, yes.
Okay, and then just looking at the left-hand side, so almost opposite it, we see a Turtle Bay restaurant.
Not entirely clear on that from the photograph.
Okay, well, certainly what you can see, whether you can identify it as Turtle Bay, you can see the brown wooden seating outside, can't you?
Yes, I can, yeah.
And then the next premises along, towards the direction of the pub in question, you can see hanging baskets and again, more seating.
Yes.
So almost directly opposite, we have two establishments providing either food and drink, a combination of.
That's correct, though we don't know the date that photograph was taken.
Right. We see, for example, that there is a Hunter's estate agent next to Turtle Bay. It's simply not a street full of clothes shops, is it?
It is now. We don't know when that photograph was taken.
Well, okay, fine. So you're saying it has changed since that date?
Yes.
So that every shop is a clothes shop?
I don't think every shop is a clothes shop, but predominantly along Carnaby Street, we have clothes shops.
Okay, but it could well be the case that there are shops such as these that we see that provide food and drink and may open, for example, depending on the date of lockdown and the requirements, for example, to provide takeaways when lockdown eased or things of that nature.
That could be possible.
Okay. Would you also agree that, as with most city centres, the city centre itself, as you've identified, is mainly shopping, but then as you expand beyond that, you'll get food outlets, supermarkets, parks, residential streets, in essence, concentric rings around the centre. You'd agree with that?
I would, yes.
Okay. And you would also agree that for people to travel, if they are on, for example, the south side of the centre, but the supermarket they wanted to go to was on the north side of the centre, they may have to travel through the central area in order to get something on the other side.
That's possible, though I suspect there are supermarkets on the south side as well.
Obviously, I mean, there will be, and it'll depend on particular locations, particular destinations, but it's entirely foreseeable that people on one side or another side of the city may need to travel through the centre of the city to get to something relatively close, just on the other side.
Yes, but perhaps not during this lockdown period.
Okay. And in terms of your review, if we can have a look at that next, page 50 of the bundle, if I could ask you to turn there, please. You've identified this document as one that you received from the Chief Executive, and we can see that it went to all departmental directors. So you're obviously the Highways Director. It would go to all the other non-highways related areas. Is that correct?
That's correct, yes.
Okay. And what we can see is that you were asked to undertake a detailed review of your activities, yes?
Yes.
On the 23rd of March. How long would such a review take you to undertake, require you to undertake? What sort of time scale?
If we were not in the unprecedented times of COVID-19, it would take a significant period of time, but things were fast moving at this time, so it took a lot less time than it would ordinarily.
Okay, and we can see in the penultimate line, it said, please can you undertake full departmental reviews and report the results to me in the next 72 hours?
Correct.
Okay. Did you provide a report in the next 72 hours?
I did verbally.
You did verbally, so there was nothing written at all?
Apart from the documents that we have.
Okay, because all we have is a risk assessment of this particular road, isn't it? Whereas what this asks you to do is consider the whole highway network.
Yes, but in terms of disclosure, we've provided what was relevant to this case.
Okay. You are justifying a decision to move from fortnightly inspections to no inspections for a period of around 4 months. I appreciate it depended on the easing of lockdown and the reopening of shops potentially. But in broad terms, you're justifying a move from a fortnightly inspection to 0 inspections for 4 months. That's right, isn't it?
That's correct.
Okay. And if we have a look at the list numbered A to D, it asks you to describe which activities can be suspended without danger to the public, what your likely staffing resources are for a skeleton service, any members of staff who can be released to other frontline services, and what resources you'll need over the next 3 months. Yep.
Correct.
They are hugely important and relevant factors to your decision as to how to maintain and inspect your highway network, aren't they?
They are, yes.
And so therefore, are they not also relevant to this case?
I don't think they are, because we're looking at Carnaby Street here.
Well, yes, of course you are. But one of the things that you are trying to suggest is the reason why Carnaby Street was inspected less frequently was because you had to reprioritise other areas, wasn't it?
That's correct, yes.
So in essence, the consideration of the whole of the network was taken into account, wasn't it?
It was.
Okay. And in terms of, can you recall what your answers were about which activities can be suspended, likely staffing resources?
Well, as we can see in this case, we looked at the frequency of inspection based on footfall and then adapted accordingly.
Okay, and was footfall the sole determinant feature?
It was the predominant feature.
Okay, so you didn't quite answer the question there. You've said it's the predominant feature. By that, I take you to mean it wasn't the only feature you took into account.
That's right, yes.
Okay, so what else did you take into account?
We also took into account our staff and the possible effect of COVID upon them.
Okay. Okay, and with the context of this particular road, explain what the relevance of that was.
Well, based upon my risk assessment, we decided to reduce the frequency of inspection of Carnaby Street and then redeployed staff elsewhere. And also we had a patch team to go around the city, identifying potholes and fixing them there and then.
Let me just stop you there, because I think you've either avoided answering or misunderstood the question. What I was asking you was, you said another relevant factor when you were undertaking the risk assessment was the staff and the impact on them of COVID-19. And I asked you what you meant by that. How was that filtered into your risk assessment?
There was a possibility that staff could have caught COVID-19 and then been away from work. So we had to decide how to redeploy staff across the highways department, should that happen.
Okay. What we see on page 51 is your risk assessment. And sorry, I should have asked, were there any other factors you took into account?
No, that was it.
Okay. So we have a look at your risk assessment, and that's dated the 23rd of March, the same day as the previous email that we looked at. Now, presumably, you've got quite a lot to do this full report in 72 hours. It's quite a lot of work, and you were quite busy at the time.
It was a busy time, yes.
Okay. And Carnaby Street is just one street within your whole highway network that you had to reassess and consider, wasn't it?
That's correct, yes, though it is the most prestigious street in the city.
Okay. When you did your risk assessment, how long were you at Carnaby Street for?
I spent approximately 2 hours on Carnaby Street.
Okay. And does that include travel time, or 2 hours actually stood there?
That's 2 hours actually stood or sat there. There are a series of benches along Carnaby Street, so I sat down.
Okay. And what did you do? You made a note of the footfall?
I made a handwritten note, yes.
That's not been produced, has it?
No, once I formulated my risk assessment and inspection policy, I destroyed that handwritten note.
Okay, you didn't write the numbers down, for example, in your risk assessment saying I've seen X number of people?
No, I didn't, no.
Did you record cars?
I made a note of cars, yes.
And so of the 72 hours that you had, you say you've spent at least, plus travel time, 2 hours just on Carnaby Street, to the exclusion of all other streets and staff and transferring staff and the other factors that are listed in that consideration.
Yes, but I was assisted in this process by my team. So I wasn't doing the whole of the network.
Okay, and what time were you there? Because it was the first Monday of lockdown, the 23rd, wasn't it?
Yes, it was, yes. I was there, I think I arrived about 11 o'clock.
So 11-ish till 1-ish?
Correct.
And just looking at the risk assessment then, can you show me where it says that you've considered anything at all apart from footfall?
No, it doesn't, no.
Okay, would you also agree that highway authorities, when undertaking risk assessments, need to consider a lot of factors, not just footfall? They'd need to consider, for example, the type of surface that particular highways have, their propensity to deteriorate due to the season, the weather, things like that, the types of vehicles using them, all those types of things.
Yes, that's correct, though Carnaby Street is largely pedestrianised, so it's restricted at most times of the day for vehicle access.
Okay. Why wouldn't you have considered any of those features, though, in your risk assessment?
Because this was a largely pedestrianised area. This had to be done quickly, and I came up with what I consider to be a reasonable risk assessment. Okay.
We can see, for example, on page 28, paragraph 12, which is your statement. That you highlight Ben Brieg took over responsibility for Carnaby Street in 2017. He's a good inspector who's found plenty of defects on his rounds over the years. Carnaby Street does have quite a lot of defects on quite a regular basis, doesn't it?
No, it doesn't, no. Ben covers 2 different areas across the city, so zones 1 and 2. So he's identified many defects across those 2 zones. So it's not just Carnaby Street.
Okay. Well, we've got the inspection record of Carnaby Street, as we've already referred to. I don't need to take it back to you, but the first line, as I identified, on a fortnightly inspection, found 7 defects on the 9th of January. That's quite a lot to rise in a fortnight, isn't it?
It is, yes, but we don't know what the weather was like at that point.
No, but my point to you is this, that when you're undertaking a risk assessment, you ought to have considered what the weather's going to be like, what the likelihood of deterioration is going to be like, what the surface is going to be like, how often it seems to degrade looking at its history, all those types of things. And you haven't considered any of those things, have you?
We've taken into account footfall. This was a dynamic and rapidly changing situation, and I consider the risk assessment process to have been reasonable.
Okay, the question I asked you was you hadn't considered any of those factors, had you? And the answer's no, isn't it?
That's right, yes.
Okay. When did you review the policy, your risk assessment?
It was not reviewed, and then the decision was taken by the government to reopen the shops. The lockdown was opened up again from the 1st of June.
Okay, so from when you did your assessment at the end of March till the 1st of June, when, for example, rules started to change and the lockdown was gradually eased, you didn't then reconsider it?
No, we didn't, though it was a dynamic risk assessment process, so it was ongoing, albeit it was not formally recorded in this document.
And you mentioned, for example, footfall, and you refer to lockdown breakage. I mean, there's been a great deal of articles and publicising of people breaking lockdown. When you were aware that people might be doing that and things of that nature, you didn't then reconsider it or change your policy or consider how to deal with it in any different way?
No, because I don't think that was a real problem on Carnaby Street, because it was largely clothing shops.
Okay. And that's despite the fact that you suggest that there was an illegal pub being run on Carnaby Street.
That's a suggestion, yes.
Okay, so it's a suggestion. You don't know whether that's correct or not?
I don't know for certain, no.
Okay. Let me ask you about the spot and patch teams. Presumably that's an additional role to normal. You wouldn't ordinarily have the spot and patch teams running as a matter of course absent the pandemic.
Excuse me, I've just heard somebody's device go off. I have to caution people, we do not want to hear any more devices going off. Thank you. Sorry, Mr. Robinson, as you were.
So the spot and patch teams I was just about to ask you about. In the ordinary course of events, would you have spot and patch teams?
No, we wouldn't, no.
Okay, so they were in essence a feature added in as a result of this. Can you explain to me, I think there was only one individual under the spot and patch teams in the end, is that right?
That's correct, yes. Due to redeployment of highway staff across the council, we had one person able to fulfil the role on the spot and patch team.
Okay, so initially I think we see from the documentation and your reference to the spot and patch team, you wanted 5 highway staff, but actually could only have 1.
That's correct, yes.
Okay, and that was because of deployment of manpower to other areas of the council.
Correct.
Okay. What were they dealing with? What was their brief? Did they deal with defects that would meet the intervention criteria? Did they have particular routes to follow? Were they just left totally free to do what they wanted? What was the position?
Well, the city is divided up into the separate areas. So the person was deployed to each area on each day, and then he would undertake a dynamic risk assessment on any defect identified by him and would then repair it accordingly if it met the risk-based approach.
Okay. So if it presented a danger potentially, he would then repair it. If it didn't meet intervention level, he wouldn't bother.
That's correct, yes.
Okay. Was his job to deal with defects that had arisen and a backlog that was there historically?
There was an element of that, but because lockdown provided us with unprecedented, unrestricted access to the network without people using it, the idea was to try and repair defects as they were identified.
Okay, well, I just want to be clear on that. And if we have a look at your document on page 53, please, which is the spot and patch scheme document. We see below dear all, I am conscious that recent months have seen us fall behind with highway maintenance in Gotham. Yep.
Yeah.
So by that you mean you're out of the timescales that you would like to have repaired the defects by under your regime?
Yes, because of the wet weather we had in the autumn and the early part of the winter, there was a lot of defects that needed repairing.
Yeah. There is a significant number of defects that have been identified by highways inspectors but have not yet been repaired.
Yeah.
And for example, we cannot say because you haven't produced the documents whether they include defects on Carnaby Street, can we?
Well, the inspection report from Ben Brigg has been produced.
Well, it tells us that he identified defects, but it hasn't produced the repairing documents, has it?
No, the works order has not been produced.
Okay. And it says, with effect, fourth paragraph, with effect from next week, I propose to requisition 5 highway staff to begin a programme of spot and patch repairs. I need 5 volunteers. So in essence, what this is saying is we want to use this time to get the people to catch up with the bits that we're behind on.
Well, that was part of it, as I said earlier, but this was unprecedented times, and with so many people being outside of our city centre, it was a really good opportunity to really get ahead on the repairs. Okay.
And you'll have been aware, and she wasn't challenged on this in cross-examination, that the claimant attended the location subsequent to the accident and subsequent to this claim being brought, and the defect in question had been filled in with tarmac.
As I understand it, yes.
Okay, which would suggest that the spot and patch individual, who I understand was the only person at that time doing repairs, would have been the one to have done it. Is that right?
I think it must be right, although we don't know that was the defect the claimant had her accident on.
Okay. We haven't heard from that individual, have we? You haven't produced a witness statement from them?
From the spot and patch team member?
Yeah.
That's correct. We haven't heard from him.
And we don't even know, for example, what they say about the defect and the repair that they undertook in that location.
No, we don't.
But as you've already conceded, they would have repaired it if there was a defect which was sufficient to create a hazard to those using the highway.
That's right. If they undertook the dynamic risk assessment and it met the criteria, yes.
Yeah. So in essence, if it has been repaired, which there's no evidence to contradict the claimant, that would suggest that there's an operative that you haven't produced any documentation or produced in person who appears to implicitly agree that there was a dangerous defect that needed repair.
Yes.
Well, forgive me, before the witness answers that question, he's asking him to agree with what is part of the ultimate issue, and moreover, that question's a comment.
Yes, I agree with that.
Okay.
We've done a lot on the generalities of the system, but what we haven't done is focused on Carnaby Street, I think.
Well, I'm dealing obviously now with defect on Carnaby Street. In terms of furlough, let me just move on to furlough now quickly. Were any staff furloughed the first time?
Sorry, what do you mean by the first time?
Well, as I understand it, the highway inspector who's not giving evidence today has been furloughed in what you describe as a second wave of furlough in your statement. So was anyone furloughed the first wave?
Not from highways, no.
Okay. But now you're in a position that you say that you have excessive numbers of staff, that you're furloughing some of them. Is that right?
We don't have excessive numbers of staff, but Ben has childcare requirements, which meant that he needed to be at home.
Right. Okay. So he's on furlough due to personal childcare reasons. Okay.
Largely, yes.
Okay. And then just finally, one final issue I want to deal with, and that's the question of complaints. What's the policy? We've not got your policy documentation within the bundle. What's the defendant's policy on complaints and responding to them under the normal regime?
So if a complaint comes in, it's passed to the highways inspector, who will go out as soon as he can or she can to identify the location and then to make a decision as to what to do. Okay.
And when you say as soon as can, as soon as they can, is there any kind of prescribed time limits? Does it have to be within 24 hours, 72 hours, anything like that?
It would depend upon the nature of the report and the location of the alleged defect.
Okay, and if it was a report of an accident and an injury, what would the response time be to respond to a complaint?
That would normally be as quickly as possible.
Would that be the same day, the next working day? Is there any kind of time limit on it at all?
It would be within 48 hours.
Was that adapted at all? There's no documentation dealing with amendments to that. Was that adapted at all? How were complaints dealt with during lockdown?
There was no formal adaptation to the policy, but it was a case of first come, first serve in terms of reports of defects.
Okay. And we know that the claims notification form, we've got it in the bundle at page 33, was dated the 17th of April. So that's when the council were notified of this accident and this defect, isn't it?
That's when the claims notification form would have gone into the insurance section, yes.
Okay. And we know that the normal highway inspector, Mr. Brieg, had been sent across, I think, to waste disposal, hadn't he?
He had at that point, yes.
Okay, so who would you have expected to deal with the complaint?
That would be another of the highways inspectors.
Okay, who in fact did deal with the complaint?
Eventually, Ben, after his return from furlough, he went out and had a look at the location.
Yeah, and that was 29th of May, I believe, 6 weeks later.
That's correct, yes.
Okay, now we know that somebody had been post-accident because we know that the defect was repaired. So can you explain why the system didn't have a procedure by which someone would go out and inspect a complaint prior to 6 weeks when Mr. Brieg returned from being seconded to a different department?
Yeah, well, we don't know that this defect, the one that's been repaired, is the one that the claimant had her accident on.
Okay. Well, be that as it may, we've obviously got the team who are going around and spotting and patching. Is there any particular reason why they or another highway inspector couldn't have been sent earlier than the 6 weeks, particularly when there's been an accident?
There's no reason, no. It may be that it was done, but we just don't have the paper trail here today.
And who would it have been done by?
Another of the inspectors.
Okay, and would they have recorded anything?
They should have done, yes.
Okay, so it was either not done or not properly recorded.
Correct.
And the spot and patch team, when they went out, would you have expected them to have records of where they went and what they did?
In terms of a general location only and the fact that they've repaired a defect, nothing more than that.
Okay, but we don't know, for example, because you haven't produced it or they haven't, whether they went to Carnaby Street, when they did, what defects they repaired, nothing of that nature, do we?
No, we don't have that, no.
Okay. Fine, I think that that is everything I wanted to ask you. Thank you.
Mr. McNamara.
Bear with me a second, please, sir, would you? You were asked some questions, Mr. Rhodes, about the dynamic nature of your assessment, and obviously matters moved on and the lockdown eased. What provision did you make at that stage, or was it separate to the policy decision that you took? Because if we look at that, which is on page 52, so my learned friends asked you a number of questions about complaints and what have you, but obviously you have the spot and patch team, and you also had in place provision for this interim inspection policy to be subject to a long stop, or alternatively it would be suspended until 14 days prior to the shops reopening. Did you go beyond this, or was that the policy that was in place when lockdown was eased?
That was a policy that was in place when lockdown was eased.
Thank you. Thank you. I don't have any more questions. Thank you, Mr. Rhodes.
Thank you.
I have no questions for you, Mr. Rhodes. Mr. McNamara, that concludes your case?
Almost, sir. What I would like you to do, please, is I would like you to take into consideration the statement of Mr. Breig, the Highways Inspector has been referred to. His statement appears on pages 22 to 24 and is also the subject of a Civil Evidence Act notice on page 25. So,
but we have no Mr. Breig.
No, that's right, sir. I appreciate it's not ideal. You've heard from Mr. Rhodes already as to why he's not here. It's a witness statement that was exchanged in accordance with the court's directions, and so the claimants have the advantage of seeing it. I appreciate the claimants not have the advantage of cross-examining him. So in the first instance, my submission is that that document is admissible. Ultimately, what weight you attach to it really is a matter for you.
There is an issue here, sir. You're no doubt aware there's been a judgment, albeit unreported, in the Nottingham County Court, Fottles and Bourne Leisure, which highlights that.
This is the Godsmark judgment, isn't it?
That's correct, sir. In the context of an adjournment application, that it isn't a good reason, or furlough isn't a reason why a witness cannot give evidence at trial. The provisions relating to furlough don't prevent them from giving evidence. So not only is it that they are not here and don't have their evidence tested, but it is also a case that the reason given for the Civil Evidence Act notice is in essence defective. Now, I accept that that doesn't make it inadmissible. Even if there hadn't been a notice, it would be admissible, but it significantly affects the weight that you should place on it, and it's important evidence relating to previous inspections.
So you're both agreed, in effect, that it's admissible, but you probably disagree as to the level of weight I should give it.
Yes, sir.
That sounds like the top and bottom of it, so yes.
Very well, I will deal with that in the judgment.
Thank you, sir. So obviously what you have is you already have a skeleton argument which is set out in the bundle of documents. In fact, you have skeleton arguments from both parties. Mine starts on page 4. So rather than simply recite what is set out there, clearly matters have moved on rather since that was drafted. In the first instance, might I simply remind you about the fundamentals of a case of this type? Highways cases invariably turn on their facts, and it is, of course, for the claimant to demonstrate her case on the balance of probabilities. My submission is that she was an entirely unconvincing witness, and in relation to significant and material aspects of her evidence, you simply cannot be persuaded to the appropriate standard that the claim is made out. I ask you to bear in mind, for example, that we have no way of knowing precisely where the location of the accident was. We have precisely no way of knowing what the extent of the alleged defect was. And so, although my learned friend, of course, will say, well, somebody came along and carried out a repair of the defect. The trouble is, in the first instance, the claimant hasn't been able to explain to you so that you could be satisfied in my submission precisely what it was she fell on. And then if you look at the ancillary evidence surrounding her fall, well, of course, we heard for the first time today that she managed to use her mobile telephone as some kind of measuring device. None of that's referred to in either the particulars of claim, the claims notification form, or, more importantly, the witness statement. She also, in the first instance, suggested rather unbelievably, and inevitably she changed her mind, that the mobile telephone fell directly into the defect, which is wholly unbelievable. She then, of course, changed tack and suggested that the mobile telephone had fallen beside the hole, and that's how she was able to shuffle around and use it as a measuring device. So my submission is that you cannot be satisfied on the balance of probabilities about what it was she fell over or why she fell over it. So the other thing that's troubling about this case, of course, is this rather fanciful idea that somehow or other she was embarking upon some salvation type activity to break the tedium or the depression of watching Titanic, an entirely self-inflicted situation as it turns out. But moreover, she changed tack about what time of day it was. Initially, of course, you will recall she said she'd watched the film in the evening and then set off on this odyssey to the ferret. And then, rather bizarrely, as a consequence, as I would invite you to find, of being prompted by somebody off screen, she changed her mind. And then when I asked her questions about what was going on in the background or off screen, she was wholly evasive, changed her evidence. I think she said it was a brother that he called to her, and so on. There are other elements of this claim, sir, in my submission, which are wholly unbelievable as well, not least, for example, the absence of any supporting documentation about the damage to or the replacement of the telephone. This ridiculous claim in relation to a very expensive pair of training shoes, supported by a letter of dubious authority, which bears no date or any. So we have no way of knowing whether the valuation placed upon them predates or postdates this accident. So, sir, my submission is that given that the claimant is such a poor historian and such a poor witness, you simply cannot rely upon her evidence as establishing the fundamentals of the case. And I remind you, sir, of the case of James against Preseli, Pembrokeshire District Council, in which the Court of Appeal insists that the claimant must satisfy the court as to the precise location, not a broad location, as to where the accident happened. And of course, the only indication you've got about the accident location is an entirely unhelpful photograph. You will recall when you look at page 45 that in fact the scene of the fall is entirely out of shot. So bearing in mind that the claimant was unable to really offer you an awful lot of assistance about, for example, things like the route to and from, then my submission, sir, is that you cannot be satisfied. Her explanation also is the subject of a contradiction, because of course her witness statement insists that she fell on the pavement, whereas when she saw Dr. McCoy, who had the advantage of speaking to her face-to-face, albeit through a video link, Dr. McCoy recorded that she fell in the carriageway. So, sir, her evidence is frankly wholly unreliable, and on that basis you could not satisfactorily form a judgment on the balance of probabilities in relation to the important factual precepts of the case.
Mr. McNamara, I'm conscious of time.
Yeah.
I have followed the claimant's evidence closely. What do you say about the Section 58 issue?
Well, sir, I appreciate that these are rather unusual times. My submission is that Mr. Rhodes's evidence was wholly practical and entirely risk-based. I note from the skeleton argument advanced by my learned friend, there's going to be some suggestion this is a case in which the question of resources, as identified by the Court of Appeal in the case of Wilkinson against the City of York, is to be addressed. But the trouble with that case, of course, is that there was some rather infelicitous evidence given by the highway inspector to the effect that the local authority couldn't afford to conform with its statutory duty. So the premise of the Wilkinson case is wholly different to this one. Here we faced a national emergency. Here we had a situation in which Mr. Rhodes entirely sensibly came to the conclusion, after proper analysis, that Carnaby Street was nowhere near as busy as ordinarily it would be. So he revised downwards the frequency of inspection.
Are you saying to me, Mr. McNamara, that I have to find what the dominant thinking of Mr. Rhodes was? If his dominant thinking was footfall, it's all right. If his dominant thinking was resources, then I've got Wilkinson problems.
Well, so although the word resources crops up, clearly what was happening is the local authority was responding to a particularly fluid situation, clearly not anticipated by the Court of Appeal in Wilkinson, and moreover based entirely upon the risk-based analysis set out in the revision to the Code of Practice in 2016. So, sir, on the one hand, yes, I would respectfully submit this is a situation in which footfall is clearly the predominant consideration. To a largely pedestrianised area where vehicular traffic is limited, presumably to early morning and late evening, then footfall is crucial. Then the other question as to resources in its broadest sense, inevitably a local authority faced with a national emergency would inevitably need to divert resources elsewhere. As Mr. Rhodes properly points out in the witness statement, if you've got the situation where what would ordinarily be a quiet cul-de-sac turned into an exercise venue for all of the people who are forced to work from home or be at home or are furloughed, then clearly a local authority would have to look at those things more frequently, as opposed to a largely commercial street lined primarily with clothing shops, as it turns out. Clearly there will be some other venues. We know the Ferret at least was there. And so in those circumstances, my submission is the risk assessment's entirely proper. Might I just say a quick thing about illegality? What you know is that this claimant was engaging in a journey which was going to take her substantially beyond the 60-minute maximum that was recommended by the government during the lockdown period.
Was that maximum recommended by the government or mandated by the government in legislation, either primary or secondary?
Your Honour, the trouble is there was no provision within either primary or secondary legislation as to an absolute limit on time spent out of the house.
So if she spent 2 hours out of the house, then she's not actually doing something illegal, provided it's for a reasonable purpose.
Yes, although of course the trouble you face in this case, sir, is that this is an entirely incredible witness, and you also have the ancillary bit of evidence about the closure of the Ferret. I appreciate the claimant says there's some confusion as to the name of the public house. Page 54, it's an indication that this is a premises that was on the face of it open for business, and potentially that she'd been working there, because that would be the only way to explain the many hours after the end of the film and the time of the accident. So for all of those reasons, for all of those reasons in my submission, the claim fails in the first instance. And even if you're against me in relation to her falling over a material defect, then the local authority's entirely practical risk-based response in the circumstances was one that any reasonable local authority would have taken, and that it can rely upon the special defence in section 58.
Thank you. Mr. Robinson, I'm a little conscious of time.
I will try and be brief, and please feel free to move me on if there's something that you don't require submissions on. In terms of the claimant's evidence, I say that it should be accepted. It is surprising perhaps the way the defendants put their case, certainly given that there's no allegation of fraud or anything of that nature. She is put to proof as to the circumstances of the accident, and I say that she has come across as a credible witness. I note in particular the tenor of the medical evidence, which suggests that she's played down her injury and has done well to recover in such a short timescale. And as such, I say that is not the conduct of somebody who is inventing or seeking material gain from a claim. In terms of the criticism relating to Preseli and the precise identification of the defect, it's not at all a Preseli case. Preseli dealt with a situation where the claimant didn't know where they had fallen and simply highlighted the poor quality of the road in general. And what Preseli says is the court has to focus on the specific defect and whether the specific defect is dangerous. Now, in this case, when we look at the evidence going to the nature of the defect, the claimant talks about a 4-inch defect, and I don't think there's any challenge at all that that would be a dangerous defect. The defendant, despite a number of opportunities to do so, has produced no evidence at all relating to the specific defect, so has no positive case to assert in that regard. But what we do know is it appears likely, and I again highlight the claimant wasn't challenged on her evidence as to the repair of the defect, that it has been repaired by the individual doing the patch repairs during lockdown. And as has been accepted, the policy is that repairs would be done to those that breached intervention level, and on a dynamic risk assessment from one of their highways inspectors. We don't know the individual because he's not been produced, but the policy would require him to undertake a risk assessment and repair it when it breaches intervention level. So implicit in that, I say, is the fact that there was a defect which breached intervention level, which the claimant identifies as the one she fell in. So taking the evidence from both sides in its totality, it is clear that on the balance of probabilities, that test under section 41 has been met. In terms of the illegality point, I say on the facts that there is no evidence of illegality. Even if you were against me on that, it doesn't meet the requirements for the claim to be debarred in essence as a result of illegality. The level of criminality in this it's a £60 fine. It's as low as it can be. The purpose of the criminal sanction was to prevent the spread of disease, not related to the circumstances of the accident. And I draw a comparison with drink driving, where if somebody's drunk, that obviously affects their ability to drive and relates to a driving accident. This has no relevance at all to the circumstances of a highway tripper. And even if you find she wasn't out exercising or had expended the time that she was allowed to, albeit that I don't think that's a legal issue in terms of the period of time out, it is more of a recommendation. That somebody could have been in exactly the same circumstance, doing exactly the same thing and had exactly the same accident, which again works against the illegality argument. Moving on then to perhaps the more unusual issue, the section 58, the defendant has a number of significant difficulties. The original inspection pre-accident, no evidence from the inspector, no proper explanation, they're not here to be tested. There's no documents from the previous inspections identifying what the previous defects were. There's no evidence as to repairs of any previous defects. And indeed, again, the defendant's evidence, where relevant, highlights that in fact it appears they were generally behind on repairs, again, which is indicative of problems with their system. And in terms of the specific defect, there's no evidence from the spot and patch man, who it appears went out and has repaired it. There's no details of what was done, the size of it, when he attended, and things of that nature. In terms of the risk-based approach and the changing of the policy, a risk-based approach is obviously fine, but they need to justify, and the law is clear on this, the basis for the changes and the decisions made. And I say that that hasn't properly been done here. It was accepted that the only considerations, and the witness, Mr. Rhodes, was given ample opportunity to explain his thinking, related to footfall, and then some slightly unclear suggestion of impact of COVID on the staff. Now, that is clearly not, in my submission, a key determinant, because they have had to second members of staff, and I'll come on to this in a moment, to other departments at the expense of the Highways Department. But their own policy requires, for example, the previous defect history, and we've seen that in a fortnight, 7 defects arose on this road, the type of traffic, prevailing weather conditions, and related to that possible deterioration. We're in March, where and April, the classical rainy, water-related months where that may have an impact. None of that was considered. None of that was addressed in the risk assessment, and it ought to have been. Furthermore, when positions changed in terms of what was allowed under lockdown, there was no further review or reconsideration, and all that appears to have been done is on the first Monday of lockdown, there was a snapshot taken which has informed the decision to reduce inspections from 2 weekly to next to nothing. And I say that that simply isn't good enough. Moving then on to the argument about resources. The case of Wilkinson is important, and there's one passage at paragraphs 34 and 35 which highlight the general principle highlighted by Wilkinson. And it says that Section 58 requires an objective judgment on risk. Elsewhere in the Act, Parliament has included manpower resources as a matter to be taken into consideration where this has been thought appropriate, and then highlights that they do not feature in Section 58. And that is what we're talking about here, manpower resources. The defendant is saying we have insufficient manpower resources, and it appears in other areas, which I say shouldn't be taken into account, such as waste disposal, which has required men to be moved from a highway context to another area. And we can see that in 2 very clear examples. The first is that 5 men were sought to do the spot and patch, and only 1 was obtained. And obviously that has an implication on the defects that are picked up, as well as those that are repaired. The other area in which we can see it having a significant on-the-ground effect is in response to complaints. and ordinarily they would expect, in response to an injury, 48 hours. Because the highway inspector himself had been taken off and put on bin duty, in essence, it took 6 weeks for anyone to look at it. And that is a clear inadequacy in their regime, which hasn't been amended as a result of COVID-19, but has simply been inadequate as a result of manpower. And indeed, there's a particular case, you're no doubt aware, Crawley and Barnsley, where in the context of a complaint, there was a complaint
I'm aware
made.
of that case. It's the complaint on a Friday and then the repair on a Monday, isn't it?
Exactly that. That was the next working day. And
yes,
that was held to undermine the Section 58 system. So clearly 6 weeks because a highway inspector has been asked to do bin work, in my submission, is very clear in undermining the Section 58 defence. Just briefly, in terms of quantum, I say the care is reasonable. It's £125. It's said to be reasonable by the expert. It'd be disproportionate to have to go and get statements. The solicitor's costs alone would exceed £125. And if you accept that the phone was broken, again, I say that £500 for a smartphone is entirely reasonable. So for those reasons, I say that the claim for quantum is maintained. The only other issue that's briefly been flagged up is the trainers, and it's accepted in the I believe the defence. I
don't need your assistance with the trainers, actually, Mr. Robinson. My teenager is something of an authority on these trainers, and they are something that is very, very expensive. It was quite a surprise to me to learn that, but it transpires that they are an expensive and rare trainer, and I'm going to have to assess in accordance with the evidence that I've got in front of me.
I'm grateful. Unless there's anything else I can assist with, then, sir.
No, there isn't. The claimant, Ms. Goings, seeks to recover compensation following a trip on the highway on the 14th of April. I have been assisted by Mr. Robinson for the claimant and Mr. McNamara for the defendant. Now, before I deal with the evidence and legal and legal arguments, I have been asked to consider admitting the evidence of Benjamin Brieg, who is not here today because he is on a furlough. The question of whether witnesses should attend and give evidence whilst on furlough is one that was considered by His Honour Judge Gosnell in Nottingham County Court back in June. In short, giving evidence is not work for the furlough scheme. There is no good reason why Brieg is not here, and I'm disappointed not to see him. As a result, the Civil Evidence Act notice is defective and not valid. I will attach little or no weight to his evidence. Turning to the claim, we've heard from the claimant today, who was struggling, doing her best to assist the court, I think. She was a confused witness and a witness who found herself in difficulties on a number of issues. She resides on Chrysanthemum Street and says that after watching the film Titanic, she had gone out for a very long daily exercise. She describes walking past the Thirsty Ferret pub. When she was cross-examined, she was evasive. I thought the point about whether she dropped her phone into the pothole or used the phone as a measuring device was important. She appeared to change her evidence when someone spoke to her off screen. We've also heard from Mr. Rhodes, the Director of Highways, who assisted the court with clear and concise evidence. He was clearly an honest witness, making admissions and concessions where appropriate. The defendant operates a system based on national guidelines, which cover both the frequency and nature of inspections. I'm told that Carnaby Street is a prestige shopping area subject to a 2-week inspection regime, maintained in a good condition for a number of years. Reference was made to Mr. Brieg and him doing a reasonably good job. The C-19 crisis changed matters, changed footfall on Carnaby Street and eliminated it as the lockdown came into place. Mr. Rhodes undertook a risk assessment. He describes a dynamic, fast-moving situation. He went to the site. He was there 2 hours. He counted cars. He counted people. He was taking a risk-based approach. It is accepted, therefore, at the time of the accident, that highway inspections were not taking place on Carnaby Street. The last inspection which took place was the 19th of March, and we see from the inspection log that no defects were recorded on that occasion. There are no documents concerning any repair to the highway complaints or the defect complained of. This is a problem for the defendant's case because, although they have given us quite a lot of material relating to the decision to reduce the number of highway inspections, what they haven't done is given us all of the background documents relating to the condition the highway was in, relating to complaints policy, and so forth. Before turning to the case, there is a COVID-related issue that I need to consider before I look at the duties under the Highways Act. This concerns the issue of illegality referred to in Mr. McNamara's skeleton. The accident occurred during the first stage of the lockdown in the UK. The coronavirus regulations applied, and there were restrictions on movement. The claimant was only allowed out in limited circumstances. Mr. McNamara has sought to suggest that the claimant was out and about because she was working at the Thirsty Ferret pub. Aside from the claimant's oral testimony denying this, that is the only evidence we have on that subject. As such, I cannot conclude, in the face of a clear denial from the claimant, that she was working that day. I accept the claimant's account that she was out for her daily exercise and consequently it was a lawful journey. Even if it wasn't, I accept Mr. Robinson's submission that this was very minor illegality and not causative of the alleged accident. To determine the claim, I need to consider three core issues. First, is the defendant in breach of Section 41 of the Highways Act, such that there was a defect present that represented a danger to users of the highway? Second, the allegation on lighting, and third, whether the defendant can establish that it has a statutory defence under Section 58 of the Highways Act, namely, and I remind myself of the section, that it had taken such care as in all the circumstances was reasonably required to secure that the highway was safe. Starting with Section 41, this is all based on the claimant. We have no documents which can demonstrate one way or the other whether there was a defect in place. It comes down to the evidence of the claimant. And with the greatest of respect to the claimant, who was doing her best to be helpful, she was evasive, imprecise, the defect had moved, she did not explain it adequately, and I saw her being guided by somebody off screen. I'm not satisfied, therefore, that the claimant can establish that there was a dangerous defect there. The inconsistencies are such that, as a matter of fact, I cannot find there was a dangerous defect present or that she tripped on it. For the sake of completeness, though, I will go on to the remaining issues. The first is lighting. That's a very simple issue to deal with. If there was insufficient lighting available, and my comments about the quality of the claimant's evidence apply, that issue is dealt with at paragraph 5 of the defence. There is no duty to light the highway, and that's Shepherd and Glossop Corporation. The next issue is the defence afforded to the defendant under Section 58 of the Highways Act. We are told by Mr. Rhodes that Carnaby Street is a prestige shopping zone and subject to 2 weekly inspections undertaken by Mr. Brieg. Mr. Rhodes confirmed in his evidence it was in good condition, and we see a road in pretty good condition in the photograph attached to the bundle. The C-19 pandemic clearly changed matters for everybody. Importantly, though, the government did not suspend the duty under Section 41 of the Highways Act. It changed the duty for everybody. The local authority undertook a risk assessment of Carnaby Street and a risk assessment relating to how often it should be inspected. This was undertaken by Mr. Rhodes. He spent 2 hours at the site. He describes a busy time there. Reminding myself of the wording of Section 58 itself, that the authority had taken such care as in all the circumstances was reasonably required to secure. All of the circumstances includes the C-19 pandemic. What was reasonable in a pandemic would not be reasonable in ordinary circumstances. As such, I find that Mr. Rhodes' approach was professional, it's sensible. I can see straight away how he reached the conclusion that he did. And so of itself, I do not think the reduction in the frequency of inspections was unreasonable or would be fatal to a Section 58 defence. The problem I have is the remainder of the system. The remainder of the system was based on complaints. We heard evidence that the complaint system wasn't changed and that complaints should be seen within a short period of time. The authority received a claim notification form on the 17th of April, on or about the 17th of April, and then did not inspect the site where they had been told there was a dangerous defect until May. That is a clear failure of the system. The spot and patch system is also problematic. If the operatives had maintained records of what they had seen and records of what they had filled, then that would avail the defendant. That would demonstrate the defendant taking such care as was reasonable in the circumstances. As it is, we don't know what they saw, what they patched, or when they patched it. The absence of documentation around the condition of Carnaby Street prior to the lockdown, and then subsequently the failure to operate the system around complaints or provide us with any evidence that the system operated around the complaints, means that taken as a whole, although it might be reasonable to inspect less often, taken as a whole, we cannot see that the authority was taking such care as in all the circumstances was reasonably required to secure that Carnaby Street was safe. Drawing all that together, the claim fails on the evidence of the claimant. And so for that reason, I have to dismiss the case. The qualified one-way cost shifting regime applies, and therefore I have to dismiss the claim and order the claimant to pay the defendant's costs not to be enforced without leave. In the defence, an issue is raised at paragraph 9 relating to the timing of the claim notification form sent on the 17th of April. The defendant was unable to investigate, so it requested more time. That was refused, and the claimant's representatives issued. If the defendant says that it has incurred additional and unnecessary cost as a result of that, the defendant will need to make an application to me setting out why it has incurred additional unnecessary costs backed by evidence. So my order in respect of that will be that the claim is dismissed, the claimant pay the defendant's cost not to be enforced without leave, and then third, if the defendant seeks permission for the cost order to be enforced or wasted costs, it should make an application to me within 21 days of today, setting out its reasons in an accompanying witness statement. I think that's all I can assist with for now. Gentlemen, anything else you need from me?
No, sir, thank you.
And thank you. I don't know if our moderator will be able to indicate this. I don't know if we have time to take any questions. I'm conscious we've overrun by 8 minutes. I'm not hearing from our moderator that we have time to achieve that. So all that remains then is to thank the players, to thank Andrew and Nick from Rope Walk. Thank you very much for that. Thank you for your assistance. Thank you to all of you out there for attending. According to the numbers, there's over 350 of you have watched this. If you have feedback on the trial, this was for us, this was an experiment, we would see how it would work. If you have feedback on how we could do it better, feedback on what you liked, what you didn't like, what was useful, what wasn't, or stuff that you would like to see from us in future, please email the addresses shown on the bundle, and we will deal with feedback and redesign things around that. It was good to catch up with all of you. I know I can't see you, but I know from the delegate list there are people out there that we know very well, and all of us here are glad to see you. We hope to be able to see you very soon when the pandemic is finished. Thank you for your time.
Thank you.
Thank you.